Narrowly, so far as the poultry here in question is concerned, the flow in interstate commerce had ceased. The poultry had come to a permanent rest in the state. The court's invalidation of the New Deal legislation presented a challenge to the other branches of government, and, after President Franklin Roosevelt's resounding re-election victory in 1936, he took up the challenge. FDR proposed his famous court-packing plan, under which he would have been authorized to appoint one new justice to the court for each current justice who was 70 years old and had served on the court for 10 years. And only half of those will be jury trials. The Robinsons made it through these filters. They found a lawyer willing to take their case, and the lawyer assessed the potential legal theories and identified defendants who might be held liable and who would be able to pay if they were. Probably the lawyer found that the driver who hit them had no insurance or assets or too little to pay for their injuries, and he contacted Audi, who refused to settle the case for an adequate amount. So he decided it was time to sue. Where can a lawsuit be brought? Two kinds of considerations are involved when a lawyer decides where to bring a suit. The first is a legal issue, which courts have the authority to hear the case. The second is a tactical issue, in which court is it most advantageous to litigate? We deal with those issues in the next few sections. The law of civil procedure frames the first issue as involving jurisdiction. Jurisdiction, translated from the Latin, means to speak the law. Anyone can speak the law, but only a court with jurisdiction can speak the law authoritatively. If a court does not have jurisdiction, or legal authority over the parties in the case, it cannot lawfully hear the case, and any decision it reaches is not valid or binding on the parties. To lawfully adjudicate a case, a court must have both subject matter jurisdiction and personal jurisdiction. Subject matter jurisdiction empowers a court to hear the kind of case at issue, and personal jurisdiction permits the court to exercise authority over the parties to the dispute. For a court to hear the Robinsons' case, therefore, it must have power over tort claims arising out of automobile accidents, subject matter jurisdiction and power to compel the defendants to litigate before the court, and, if the Robinsons win, to pay a judgment. Personal jurisdiction. 3 states have a logical relationship to the accident and the parties that makes them obvious places to bring suit. The accident occurred in Oklahoma. The Robinsons had purchased their Audi in New York from Seaway Volkswagen, one of the defendants, and they were still legal residents of New York at the time of the accident, and they were on their way to establish a new legal residence in Arizona. Therefore, they might logically have brought suit in the courts of Oklahoma, New York, or Arizona. We restrict our analysis to American courts. It is possible but unlikely that they would have sued in Germany, the home of Audi. Every state has a set of courts called courts of general jurisdiction that are empowered to hear most kinds of civil cases, including tort, contract, and property claims. These are the basic level trial courts that hear the bulk of the state's judicial business. Usually the subject matter jurisdiction of courts of general jurisdiction is unrestricted. The state constitutional provision or statute that gives them authority is expressed in broad language, giving them original jurisdiction in all civil, probate, and criminal cases, except as otherwise provided herein, as the Colorado Constitution provides. By tradition, the general jurisdiction courts of different states have different names. In Arizona, the Superior Court is the Court of General Jurisdiction. In Oklahoma, it's the District Court. And, strangely enough, in New York the General Jurisdiction Court is known as the Supreme Court. In New York, the highest court in the state, which is known practically everywhere else as the state's Supreme Court, is called the Court of Appeals. Every state also has courts of limited jurisdiction, such as a family court, whose subject matter jurisdiction is limited to divorce and child custody issues, a probate court, with jurisdiction limited to inheritance matters, and a small claims court, which has jurisdiction only over cases involving relatively small dollar amounts. Another traditional division of courts is into law and equity. As the royal courts became more rigid and bureaucratic in the 13th century, frustrated litigants turned to the king as the fount of justice. the king assigned his right-hand man, the chancellor, to provide more flexible justice in cases in which the law courts would not. Over time, the chancellor's exercise of discretion itself became institutionalized in a court of chancery, or, because its goal was fairness, of equity. The existence of two competing judicial systems became a point of conflict in the struggles between the Crown and Parliament and, later, between the Crown and American colonists, for whom the equity courts were a symbol of imperial authority. Beginning in the 19th century, the conflict faded as law and equity merged into a single system. Today, equity remains important as a distinctive set of remedies and procedures. When a litigant seeks an injunction, a court order compelling someone to do or not do something, rather than money damages, for example, it is an equitable matter. Injunctions are available in some private cases when the legal remedy of damages is inadequate, as when one business seeks to enjoin another from illegally using its trademark. They also are used in civil rights cases and similar public litigation. The desegregation of schools in the South through the 1950s and 1960s was ordered by federal courts exercising their equitable powers. One final, important consequence of the distinction is that, in equity, the judge decides the case without a jury. The Robinsons also have to sue in a court that has personal jurisdiction over the potential defendants. In most cases, personal jurisdiction is easy. Suppose first that they want to sue the driver of the Ford that hit their car. They certainly can do so in Oklahoma, the state in which the accident occurred, because committing a tort in a state provides a basis for jurisdiction. If the Ford driver lives in Texas, the Robinsons can sue him there, because a person always can be sued in the state in which he or she has legal residence. But the personal jurisdiction issue is trickier when the defendants have a less obvious relationship to the state in which the suit is brought than when they are corporations, not people, for whom it is harder to pin down where they are and where they act. Which courts, then, have personal jurisdiction over Audi, Volkswagen, Worldwide, and Seaway? This issue has been addressed in a series of confusing U.S. Supreme Court cases dating back more than a century and featuring Worldwide Volkswagen Court v. Woodson, as the Robinsons case was called when it reached the Supreme Court in 1980. To make it simple, think about why we feel comfortable if the Robinsons sue the Ford driver in Oklahoma or in his home state of Texas. In either of those cases, the driver can't really complain that it is unfair for the court to exercise jurisdiction over him. In each case, there is a sufficient connection between the driver and the forum state, the state in which suit is brought, so that it seems fair to make him defend an action brought in the forum state's court. It doesn't seem unfair to require someone to litigate in a state in which he is involved in an accident, and it certainly isn't unfair to require him to litigate in his home state. And, in each case, the forum state has a legitimate interest in adjudicating the dispute. Oklahoma ought to be able to try cases involving accidents on its highways, and Texas should have the power to decide actions against its residents. The Supreme Court distilled this sense of fairness into a constitutional requirement in the case of International Shoe Company v. Washington, 1945. The Due Process Clause of the Constitution limits the ability of a state to exercise personal jurisdiction by requiring that the defendant have minimum contacts with the forum state, so that requiring him to defend there does not offend traditional notions of fair play and substantial justice. This really makes first-year law students crazy. The court creates an intensely complicated body of law and ostensibly grounds it in a concept like fair play that everyone should be able to understand. The Robinsons attempted to sue the four Volkswagen defendants in Oklahoma, but the Supreme Court said that an Oklahoma court could properly assert jurisdiction only over the manufacturer, Audi, and not the distributor or dealer, Worldwide and Seaway. Audi sells its cars in a national market, so it has contacts with every state and should reasonably expect to be subject to a suit when one of its cars malfunctions in any state. It obtains the benefits of doing business everywhere, so it must accept the responsibility of being sued anywhere. Worldwide and Seaway, however, sell cars only in the New York area. Although they could foresee that some of their customers would drive to Oklahoma, it would be constitutionally unfair to require them to go there to defend suits in the absence of any other contacts between them and that state. When can you make a federal case out of it? The Robinsons brought their case in the district court in Creek County, Oklahoma, part of the Oklahoma state court system, but they could have made a federal case out of it by bringing suit in the federal courts. The United States has a court system parallel to the state court systems. Like most state systems, the federal judicial system has trial courts, called the U.S. District Courts. intermediate appellate courts, called the U.S. Courts of Appeals, or sometimes the circuit courts, from the days when Supreme Court justices rode circuit to hold court in different places, and a highest court, the U.S. Supreme Court. The system is geographically organized, with, for example, a U.S. District Court for the Northern District of Oklahoma and a U.S. Court of Appeals for the 10th Circuit, hearing cases from Oklahoma, Colorado, Kansas, New Mexico, Utah, and Wyoming. Although the federal court system looks pretty much like the state systems, on the issue of jurisdiction the systems are fundamentally different. In the state courts, jurisdiction over the kind of case, subject matter jurisdiction is usually easy because the trial courts have general jurisdiction over most kinds of cases, but jurisdiction over the defendant per se jurisdiction is subject to the constitutional limitation of sufficient contacts with the state such that it is fair to assert authority over the defendant. In the federal courts it is just the opposite. Personal jurisdiction is unrestrained by constitutional due process requirements. Even though the district courts sit locally, they are all part of a national system that can assert jurisdiction over defendants by court rule. However, federal district courts assert personal jurisdiction over defendants only to the same extent as the courts of the states in which they sit. Subject matter jurisdiction is much trickier, though, because the federal courts are courts of limited jurisdiction. They have authority only to the extent that the Constitution and the Congress have granted it to them. So unlike the state courts, the federal courts only hear cases in particular categories. If each state has a judicial system, why do we need a set of federal courts at all? The framers of the Constitution and the Congresses that enacted enabling legislation had two reasons for establishing federal courts. First, some cases involve important national issues that should be decided by judges of the U.S. government rather than of any particular state. Second, Americans always have been a bit parochial, so the framers wanted to provide a neutral forum for, say, New Yorkers who had to litigate in Oklahoma. Each of those reasons resulted in a particular kind of authority for the federal courts, known respectively as federal question jurisdiction and diversity jurisdiction. In addition, there are a few other classes of cases given to the federal courts, such as admiralty cases, which involve maritime affairs, and suits in which the U.S. government is a party. The first type of federal subject matter jurisdiction is federal question jurisdiction. Under the Constitution and statutes, the power of the federal courts extends to cases arising under the Constitution, federal statutes, and federal administrative rules. Federal courts hear cases involving the whole range of federal law, including the environmental laws, Social Security, Food and Drug Administration regulation, and violations of constitutional rights. Sometimes, as with civil rights, the states also have jurisdiction over these issues. A claim that a shopping mall is infringing on free speech by preventing leafleting can be brought in state or federal court. In other cases, the federal courts have exclusive jurisdiction. Only a federal court, for example, can hear a bankruptcy case or a patent claim. The federal courts are believed to be in a better position than the state courts to develop expertise, to make the law more uniform, and to consider national interests in the interpretation and application of federal law. In addition, many federal laws are unpopular when applied to local controversies, and vesting federal courts with jurisdiction over them makes it more likely that the laws will be enforced free of local prejudice and political interference. Through the 1950s and 1960s, for example, the federal courts were primarily responsible for enforcing civil rights laws in recalcitrant southern states. Diversity jurisdiction is designed to prevent prejudice against out-of-state litigants. The framers wanted to avoid bias by local judges and juries against litigants coming from other states, or at least to allay the fears of out-of-staters about the possibility of bias. Diversity jurisdiction also permits many economically important cases, those involving large, commercial transactions between companies from different states, for example, to be heard in the federal courts, where to sue initially is the plaintiff's choice, but the concern for local prejudice underlying diversity jurisdiction has historically been so great that defendants were given a similar choice through a doctrine known as removal. If the plaintiff brings the action in state court, an out-of-state defendant can remove it to federal court, as long as the federal court would have had jurisdiction in the first place. That way a New York defendant, for example, can avoid the prejudice that might result if sued by an Oklahoman in an Oklahoma state court. By removing the case to the U.S. District Court in Oklahoma, The two traditional requirements for diversity jurisdiction are a sufficient amount of money at stake in the case and diversity of citizenship between the parties. The amount in controversy requirement is a simple one. The plaintiff's claim has to be worth more than a minimum amount set by Congress to be brought in federal court. The diversity of citizenship requirement is more interesting. In most cases, to establish federal jurisdiction there must be complete diversity. That is, the plaintiff and the defendant must be from different states, and if there is more than one plaintiff or defendant, all of the plaintiffs must be from different states than all of the defendants. This is the key to the Robinsons case. The Robinsons claimed that the gas tank on their Audi was defective and caused the fire that injured them, so they sued Audi and Volkswagen of America, the manufacturer and importer of the car. If the gas tank was defective, Audi and Volkswagen were the ones responsible, and they certainly had the assets to satisfy any judgment against them. So why did the Robinsons also sue Worldwide Volkswagen, the regional distributor of Audis, and Seaway Volkswagen, the dealer from whom they bought the car? The answer is a strategic choice made by their lawyer using the law of diversity jurisdiction. The Robinsons had not completed their move from New York to Arizona, so they were still citizens of their former home, New York. For diversity purposes, Audi was a German company and Volkswagen of America was a New Jersey corporation, but Worldwide and Seaway were both New York corporations. Bringing them into the case destroyed complete diversity, which meant that the case could not be heard in federal court. Of all the possible forums, state and federal courts in New York, Oklahoma, and possibly Arizona, the Robinsons' lawyer decided the best place to sue was in state court in Creek County, Oklahoma, then considered one of the most sympathetic jurisdictions for personal injury plaintiffs in America. With Worldwide and Seaway in the case, the defendants could not remove the case to federal court in Tulsa, which was much less attractive from the Robinsons' point of view. Although the Robinsons' lawyer made the correct calculation about destroying diversity jurisdiction, an issue of subject matter jurisdiction, he ran up against the law of personal jurisdiction. Seaway and Worldwide challenged the ability of the Oklahoma State Court to assert jurisdiction over them, and the U.S. Supreme Court agreed, holding that it would be unfair to force the New York distributor and dealer to litigate in Oklahoma. With the New York defendants out of the case there was complete diversity, so Audi and Volkswagen could and did remove the case to federal court, where a jury found that the speed of the car that struck the Robinsons' Audi, and not a defect in the gas tank, was the cause of the fire. Cases like the Robinsons cause some critics to question whether diversity jurisdiction is still necessary or useful. Today, the critics argue, diversity is more commonly used as a lawyer's tactic than a protection for out-of-state defendants. Local prejudice against out-of-staters has declined to a considerable extent, so the value of fair process no longer requires a neutral federal forum. Moreover, federal courts apply the same substantive law as state courts and draw their judges and jurors from about the same locales as the state courts, so the differences between the two forums have diminished. We could, they say, eliminate diversity jurisdiction and reduce the workload of the federal courts, though this would, of course, increase the burden on the state courts, as we can see from the Robinsons case. Where a plaintiff can sue and where he or she should sue often are two different questions. Under the jurisdictional rules, a plaintiff may have a choice of courts, state or federal, New York or Oklahoma. Choosing among those forums is a tactical issue for the plaintiff's lawyer. A lawyer simply may choose to litigate at home, in the jurisdiction where the plaintiff lives and the lawyer practices, and the only decision to be made is state or federal court. One court system may be more expeditious than another. In some urban areas, the wait to go to trial may be 6 years in a state court and 2 years in a federal court, or the difference may be as great in neighboring state jurisdictions. As with the Robinsons, the probable composition of the jury may differ from one court to another. The rules of civil procedure may be more attractive for one reason or another. Often the federal discovery rules are broader and more efficient than comparable state rules. The quality of the judges may differ as well. There is a traditional belief that federal judges are of higher quality, at least in some respects, than state judges, and, again, judges in one jurisdiction may be better regarded than those across the river or down the road. If you can sue in different places, what law will apply in each place? One consequence of having different state court systems and a parallel federal system is that different bodies of law potentially apply to a single case. The Robinsons brought their case in Oklahoma State Court. If they had gone to federal court instead, would the federal court have applied different law to determine if the Audi's gas tank was defective? Or if they sued in New York, would New York's tort law have applied to the case instead of Oklahoma's law? Because the law varies from place to place, issues like these often determine the outcome of the case. So it is essential that civil procedure have ways to resolve them. Two kinds of conflict between the law in different jurisdictions are easily resolved. Generally, a court applies its own rules of procedure, whatever substantive law applies to the case. Also, when a state court has a case involving federal law, it applies the federal law, including federal court decisions interpreting the law, because the Constitution makes federal law the supreme law of the land. Two other kinds of conflict are much more complicated. The first involves a federal court hearing a diversity case, as when the U.S. District Court in Oklahoma hears the Robinsons suit against Audi. Is the federal court bound by Oklahoma tort law, or can it develop its own rule about when a product is dangerously defective? The U.S. Supreme Court has declared that federal courts must follow state law on all substantive issues. Therefore, a federal court in a diversity case applies the same principles of tort law, contract law, and so on as would be applied if the case were in state court. The second kind of complex interjurisdictional conflict is between two bodies of state law. Suppose Oklahoma holds manufacturers strictly liable for defects in their products, but New York holds them liable only when they have been negligent in making their products. For more on products liability, see Chapter 5. Can the Robinsons avoid the New York rule by suing in Oklahoma? This issue falls within the area of law known as conflicts of law and requires a choice between the law of competing jurisdictions. The law of conflicts of law is among the messiest areas in the entire body of the law. Its uncertainty tortures students, and its complexity often baffles courts. The reasons for this confusion illustrate something very basic about law. Until about the middle of the 20th century, the law of conflicts of law was composed of what purported to be relatively clear rules, based on territorial notions of sovereignty and justice. For example, a tort case would be governed by the law of the jurisdiction in which the accident occurred. An accident in Oklahoma would be controlled by Oklahoma tort law whether the case was tried there or in New York. Similarly, a contract dispute would be governed by the law of the state in which the contract was made. Unfortunately, many transactions have a multi-state character. What law governs an action by the Robinsons, who purchased a car in New York that was made in Germany and that was involved in an accident in Oklahoma? Did the relevant wrongful act occur when the car was made, sold, or burst into flames? Is it fair to subject Audi to the tort rules of 50 different states, including some states in which it may not even sell cars? Moreover, courts became uneasy about applying the law of another state that conflicted with their own rules. As the courts grappled with these issues, they created counter-rules and exceptions to the rules that generated confusion and ultimately much criticism. Judges and scholars were very successful in criticizing the old rules but less successful in formulating new ones. The results in particular cases have become unpredictable in many states, as courts abandon the old rules in favor of flexible standards requiring them to weigh and balance a multiplicity of factors, and many jurisdictions never came on board, implicitly or explicitly clinging to the older rules. As a result, things are different but not necessarily better. The lesson from all this is that clear, rigid legal rules are often not what they appear to be. They either produce injustice as they are applied to varying fact situations, or they demand interpretations and exceptions. Yet interpretations and exceptions cause complexity and uncertainty. Broad, flexible legal rules, on the other hand, give the courts great discretion, and discretion produces conflicting decisions and uncertain rules, which is another form of complexity and injustice. How does a lawsuit begin? A lawyer begins a suit by preparing and filing with the court a document known as a complaint, in which, as its name suggests, the plaintiff, the person who is suing, complains that the defendant, the person who is being sued, violated his legal rights and asks the court for a remedy. The law doesn't require that a lawyer file the complaint or otherwise represent the plaintiff. Anyone can represent himself. The term for this is pro se, Latin meaning for oneself. As a practical matter, though, outside of small claims court, a lawyer is a necessity. Attached to the complaint is a summons, a document from the court that summons the defendant to respond to the charges. The plaintiff must cause service of process on the defendant by having a copy of the complaint and summons delivered to the defendant by a sheriff, process server, or mail, depending on the rules of the court in which the case is filed. The complaint begins to define what the litigation is about. In the Robinsons case, for example, the complaint would state sent who the Robinsons and the Audi defendants were, that the Robinsons had purchased an Audi from Seaway Volkswagen, sent how the Audi had been involved in an accident, how the Audi was defective, that the defect caused injuries to K. Robinson and the children, and for those reasons, the Audi defendants ought to pay the Robinsons money. This information serves several purposes. First, it lays the basis for the jurisdiction of the court. By stating that this case involves an automobile accident that occurred in Oklahoma, the complaint makes clear that the case can be brought in Oklahoma District Court. Second, it notifies the defendants that they are being sued and why they are being sued. Adequate notice to the defendants enables them to hire lawyers and to begin to think about the basis on which they will contest the plaintiff's claims. Third, it frames the issues of fact and law that will be involved in the case and, by implication, the issues that will not be involved, by going through the elements of the cause of action, why the plaintiffs claim they are entitled to relief because of what they allege the defendants did wrong. The complaint tells the parties and the judge what will be relevant to the ultimate decision in the case. On the facts, for example, the speed of the Robinsons' car and the other car involved in the accident will be relevant, because excessive speed rather than a defect in the Audi may have caused the fire, so both parties may want to investigate and, at trial, present proof about the speed of the cars, whether the defendants defrauded the Robinsons by advertising the car as having a high-fidelity sound system when it actually had a cheap, tinny system is not relevant, though, because that claim has nothing to do with the accident. The parties should know not to investigate or present proof about the sound system. If they try to do so anyway, the judge will know to stop them. Traditionally, the complaint and other pleadings were the exclusive means of defining the issues in the case for the parties and the court. Judges required that a lawyer plead the facts underlying the claim specifically and precisely. If a lawyer failed to do so, if, for example, the Robinsons' lawyer misstated Audi's corporate name or failed to specify how exactly the defect occurred, the case would be thrown out of court. Because this hypertechnicality conflicts with the goals of serving the values of the substantive law and providing fair process, judges have relaxed the pleading requirements, and the process of defining the issues in the case begins with the complaint but continues through the discovery and pre-trial stages of the case. The Robinsons' lawyer can state in the complaint that the Audi was defective and subsequently try to pin down exactly what the defect was. As an illustration of this flexibility, if a lawyer makes a mistake in pleading or discovers new information that reveals a pleading to be incomplete or incorrect, the court usually allows the pleading to be amended to correct the error or account for the new information. The Robinsons originally sued only Volkswagen of America, Seaway, and Worldwide, but subsequently they amended their complaint to add Volkswagen AG, the German corporation who they thought was the manufacturer. When they learned through formal discovery that Audi AG, a different German company, was really the manufacturer of the car, they amended again to substitute Audi for Volkswagen. Indeed, the rules on amending pleadings are so liberal that a party usually can amend at or after trial, so that the pleadings match the proof presented at trial. As long as the defendant has fair notice of the basics of the case, justice is served by focusing on the substance rather than the lawyer's technical compliance with pleading rules. This does not mean that there are no limits on pleading. However, everything in a pleading has to be grounded in fact and stated in good faith. And, depending on the jurisdiction, either the party must swear to its truthfulness or the attorney filing the pleading must sign it. The federal rules, for instance, require an attorney to sign a pleading and attest to the fact that she has concluded, after reasonable inquiry, that the pleading is well grounded and that she is acting in good faith and without improper motivations in filing the pleading. If a statement in a pleading is false or frivolous, the court can impose penalties on the party or on the attorney. The vigorous application of rules such as this creates a significant incentive for attorneys to be careful in drafting and investigating the accuracy of pleadings. What can the defendant do to respond to a lawsuit? Someone first receives official notice that he is being sued by receiving the plaintiff's complaint and an accompanying summons from the court. The summons typically directs the now defendant to answer the complaint, but the defendant actually has a number of different ways of responding to being sued. First, the defendant can simply ignore the whole thing. If the defendant in a criminal case fails to answer a summons or appear for trial, the police can go out and arrest her, Not so in a civil case. If Worldwide Volkswagen receives the Robinsons' complaint and summons in the mail and doesn't do anything in response, the police won't come and drag the company's president into court. But that doesn't mean that anyone can just ignore a complaint. The sanction for failing to respond to the complaint is that the plaintiff can get the court to enter a default against the defendant. A default prevents the defendant from subsequently entering any defenses on the merits of the case, and the plaintiff can proceed to get a default judgment that concludes the case against the defendant and then can attempt to enforce it like any other judgment. Sometimes the defendant may take the chance of ignoring a complaint and having a default judgment entered against it because the defendant doesn't think the plaintiff will be willing or able to enforce the judgment. Suppose the defect in the Audi had not caused serious injuries but had required only a minor repair costing $200. If the Robinsons had for some strange reason sued for this small amount, Worldwide might have ignored the suit, figuring that either it wouldn't be worth the money to hire a lawyer in Oklahoma to defend a suit for such a small amount, or the Robinsons wouldn't bother to go to New York to try to collect it. Ordinarily, though, if it is worthwhile for the plaintiff to sue, it is worthwhile for the defendant to respond. So the defendant will do something other than ignore the complaint and risk a default. The second tack the defendant can take is to raise an objection to being sued that is unrelated to the merits of the case. The objection takes the form of a motion to dismiss. A motion is a formal request to the court to get rid of the case without ever reaching the substance of what happened. Some of these objections are trivial. A defendant can say that there was a technical defect in the form of the summons or in the method of service of process, sending the complaint and summons by mail. For example, when personal service is required, if the plaintiff can cure the defect, in this case by personally serving the defendant, then the objection may delay the case but doesn't halt it altogether. If the plaintiff cannot cure the defect because the defendant is unavailable to be served, then the defendant's strategy may prevent the case from going forward at all. A more important basis for a motion to dismiss is that the court lacks jurisdiction over the defendant or the case. Recall that a court can render a binding judgment only in a case where it has jurisdiction, or authority over the subject matter of the case and over the parties. If the defendant demonstrates that the court lacks jurisdiction, the court has no power to do anything other than officially recognize its lack of jurisdiction by dismissing the case. This is effectively what Worldwide Volkswagen and Seaway Volkswagen sought in the Robinsons case, arguing that the Oklahoma State Court had no personal jurisdiction over them because they had no contact with the state other than the fortuity that the Robinsons drove their car there. Worldwide and Seaway asked to be let out of the case without I'm to defend on the merits. The third move the defendant might make is to challenge the legal sufficiency of the plaintiff's complaint. This procedure was classically known as a demurrer and is today more commonly referred to as a motion to dismiss for failure to state a claim or failure to state a cause of action. In such a motion to dismiss, the defendant argues that even if all of the facts that the plaintiff alleges are true, there is no legal basis for holding the defendant liable to the plaintiff. The motion therefore tests the strength of the plaintiff's legal argument without getting into the facts underlying the dispute. Suppose, for example, that Oklahoma tort law states that the manufacturer of a defective product is strictly liable to a consumer who is injured by the product, but the distributor of the product who did not manufacture it is not liable to the consumer. Seaway Volkswagen could move to dismiss the Robinsons' action against it for failure to state a claim, even if the Audi was defective and the defect contributed to their injuries. Under the law Seaway, the retail dealer, is not liable to the Robinsons. Seaway is in the same position as if the Robinsons had sued Ford, GM, or IBM. Whatever the facts of the case, the law provides no remedy against this defendant. If the defendant has no basis for making a motion to dismiss the complaint, or if any motions to dismiss fail, the defendant finally has to meet the complaint on the merits of the case. The defendant does this by filing a pleading called an answer, which, obviously, answers the allegations made in the plaintiff's complaint. The defendant can meet the plaintiff's allegations in three ways: by saying no, denying that the allegations are true, I don't know, disclaiming knowledge about the allegations, or yes, but admitting the allegations but stating facts that would provide a defense to the plaintiff's claims. Ideally, a defendant might like to deny everything the plaintiff said in its complaint, thereby hiding all the information the defendant has about the case and putting the plaintiff to the trouble of proving every piece of information it needed to establish its claims. In former times and in a few jurisdictions today, the defendant could accomplish that through a general denial, which places it Robinsons for some reason decided to sue only Seaway, the dealer from whom they bought the car. Seaway could have inflated Audi, brought Audi in as a defendant, on the theory that either by contract or as a matter of law the manufacturer has to pay any damages for which the dealer is held liable, due to a product defect. Seaway could also have brought in the driver of the other car, claiming that it was his negligence that was responsible for some or all of the Robinsons' injuries. In addition to involving multiple parties, lawsuits often involve multiple claims. This is obviously the case when the Robinsons sue the Audi defendants on a product's liability theory and the other driver for negligence. But it can get even more complicated. One species of claim is called a counterclaim, in which the defendant sues the plaintiff back. If the driver of the other car was injured in the accident, when the Robinsons sue him, he will respond with the counterclaim against them, alleging that their negligence was liable for his injuries. This is so obviously connected to their claim against him that the courts require him to bring it in the same action. If he doesn't, he cannot subsequently bring a different suit for his injuries. In other cases, the counterclaim is not so intimately connected to the events at issue that it must be considered at the same time, but the defendant may bring it because the parties are in court and litigating anyway. Suppose immediately after the accident Harry Robinson, not having been seriously injured, jumps out of his car and shouts, "You maniac, look what you've done," and punches the other driver in the face. Either in the Robinson suit or in a separate suit, the other driver can bring a claim for battery for being punched. Even though relatively little of the evidence overlaps their claim for the accident and his claim for the punch, the counterclaim can be brought in the original action, but because it would unduly complicate trials if defendants had to bring as counterclaims all claims they might have against the plaintiff, no matter how loosely related to the main event, the driver can save his battery claim for another time. One other type of claim occurs when defendants begin fighting among themselves. Suppose that after the accident the Audi catches fire and injures the Robinsons and the driver of the other car. The Robinsons name Audi and the other driver as defendants in their action, saying that the driver's negligence caused the action and the product defect made it worse. The driver may file a cross-claim against Audi, alleging that his own injuries occurred because the defective Audi caught fire. The cross-claim is just like a new action except it is between defendants and can be tried with the main action. What if there are many parties to a lawsuit? Sometimes there are so many parties, usually on the plaintiff's side, occasionally on the defendant's side, involved in a single lawsuit that the court treats them as a group rather than individually. This type of suit is known as a class action, because the individual parties represent many members of a class of people like them who are, as the law says, similarly situated, that is, the other class members share the same grievance. Suppose that the Robinsons had financed the purchase of their car through Volkswagen's in-house finance company. They believed that the finance company had overcharged them by miscalculating the interest rate on the loan, and other customers of the finance company believe they have been overcharged in the same way. If there are 100, 1,000, or 1,000,000 such cases, it may be more manageable to have the case tried as a class action in which the issue of overcharging can be determined once for all the plaintiffs. In a class action, the Robinsons can bring a class action on behalf of themselves and the other customers. As class members, the other customers do not actually participate in the conduct of the litigation and probably do not even know about it, but they will be bound by its outcome. The numbers involved in class actions range from the large to the spectacular. A hog farm alleged to emit noxious odors was sued by a class of 450 nearby property owners. An explosion at a Shell oil refinery resulted in a class action involving 80,000 injured plaintiffs. 5 million merchants were in the class that sued MasterCard and Visa for antitrust violations. By allowing plaintiffs to bring class actions, courts attempt to balance the conflicting goals of civil procedure. The ultimate goal, of course, is to carry out the policies and values of the substantive rules of law, especially when many individual plaintiffs each have relatively small claims. This can be done only through a class action. A borrower may pay a few dollars more when the finance company miscalculates the interest rate, because of the small size of the claim and the expense of litigation. It isn't worthwhile for any one borrower to sue. The collective loss of all borrowers, though, is very large. By bringing one suit for all of the borrowers, A class action makes sure that the law against misrepresenting interest rates is carried out and the people who are injured by the wrongful conduct are compensated. Aggregating claims in a class action where it would be impracticable to join all the claimants also serves the value of operating the litigation system efficiently. A class action always involves at least one issue of law or fact that is common to all the claims, such as whether the interest rate was miscalculated. Examining and deciding that issue once is more efficient than doing it over and over in different cases, where the facts or law applicable to each claimant differ too much. However, efficiency is not served by a class action, even if 1,000 other Audis like the Robinsons were involved in accidents in which a defective gas tank allegedly caused a fire. Those cases would be less suitable for class action treatment because the evidence about the specific facts of the accidents and the resulting injuries would be so different. Because most class members do not participate in the litigation, class actions also implicate special fairness concerns. All members of the class will be bound by its result, so courts are required to give absent class members adequate notice of what is happening, allow them the opportunity to opt out of the class action and sue on their own, and make sure that the class representatives and their lawyers provide fair representation for the interests of the absent members. Because of their massive scale and because the potential cost to the defendant of an adverse judgment is so great, class actions often are settled rather than tried. Indeed, sometimes class actions are brought with the purpose of being settled. The plaintiff's lawyers and the defendants will negotiate and arrive at a settlement before or shortly after the case is filed, without ever really expecting to go to trial. In these cases, the court has a heightened obligation to scrutinize whether the case is appropriate for a class action and whether the proposed settlement is fair. The law on class actions is very complicated and hotly disputed. Some courts use on class actions as an effective means of disposing of large numbers of claims in a relatively expeditious manner. Even though a class action can be complicated and cumbersome, it is still better than thousands or tens of thousands of individual cases. Other courts are more reluctant to use the device in very large cases, believing that the farther away one goes from the traditional paradigm of adjudication, a well-defined dispute between two adverse parties, the less well-equipped a court is to deal with the problem, and many businesses are hostile to class actions, viewing them as a bludgeon used by plaintiffs' lawyers to coerce massive settlements and generate huge fees. One of the products of this controversy was the Class Action Fairness Act, enacted in 2005, long sought by the tort reform movement. The act cuts back on some of the uses of class actions that most trouble business interests. The act shifts many class actions to federal court, which is likely to delay or even prevent the adjudication of class actions. Because the federal courts are busier, federal judges are thought to be less tied to class actions than state judges, and they are prone to dismiss the class actions altogether when conflicting bodies of state law must be applied. The act also cracks down on attorneys' fees and coupon settlements. In a coupon settlement, the members of the class do not receive cash damages. Instead, they receive a coupon that can be used as a credit or discount in a future transaction with the defendant. For example, in an antitrust action against Nintendo, purchasers of a video game system were given $5 coupons good toward a game. Under the act, as before, the court has to scrutinize carefully the fairness of coupon settlements. The court also now must base the attorney's fees on the amount of coupons actually redeemed, not just issued. Typically, many class members receiving coupons will not redeem them. Teenage video game users might just ignore or forget about the Nintendo coupon. How do the parties discover the facts about their case? This is handled through a process called, naturally enough, discovery. It's easy to find out some of what a party needs to know during litigation. The Robinsons, for example, know the speed at which they were driving before the accident and how extensive their injuries were. Audi, on the other hand, knows how the fuel tank was designed and built, but each of them wants information that the other has. The Robinsons want to know about the fuel tank, and Audi wants to know about the accident and the injuries. It would be possible to proceed to trial without each party finding out in advance what the other knows. That was the traditional common law system, in which the facts were only minimally developed through the pleadings and the parties had no other opportunity before trial to find out what the other knew. But modern civil procedure uses a more open system in which each party has an extensive opportunity to unearth all of the facts relevant to the litigation during the pre-trial stage of the litigation, to obtain information that is in the adversary's possession, or that can be most easily obtained from the adversary even though it may be available elsewhere. A party can interview the other party under oath, called a deposition, submit written questions, called interrogatories, demand that documents or other physical evidence be produced, require the other party to submit to a physical examination, and ask the other party to admit the truth of facts relevant to the litigation. A deposition is an oral examination of the other party or someone else with knowledge of the case. A deposition